All right. Good afternoon, everyone. Happy Friday. My name is Jorge Acosta Palmer, and I'm the director of the statewide training initiative. Thank you for joining us here today to learn about defending depositions. Before I introduce our speaker, I do want to go through some housekeeping announcements. This training is being recorded. You will receive a copy of the recording in an email from Zoom within 24 hours. If you don't see that email, I'm going to drop my email into the chat just in case. Feel free to reach out to me and I'll get you anything that you need. As far as CLE goes, this training is approved by the Florida Bar for CLE Credit. I'll announce the CLE code towards the end of the session. I will also drop the CLE information on the chat, and it will also be included in the Zoom email that will go out afterwards. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or the captions, you can reach out to me directly. This training is being hosted by the Public Interest Law section of the Florida Bar, also known as PILS. If you're not familiar with PILS, I highly encourage you to visit their website and take a peek. Annual membership is only $35. It's a pretty cool section, and there are a lot of benefits joining if you're a public interest attorney. They have a lot of subject matter work groups and operating committees. You can take a look on their website, and I'll drop it on the chat as well. And final piece of housekeeping announcements are questions and answers. If you have any questions during the presentation, feel free to drop them into the Q&A section. And towards the end, if time permits, we'll go ahead and answer as many questions as we can. So without further ado, I'd like to introduce our speaker, Professor Robert Bonner. Professor Bonner joined Barry University School of Law as an assistant professor in 2022. Since joining Barry, Professor Bonner has taught civil procedure, Florida civil practice, motions and depositions, and products liability. Professor Bonner also serves as the faculty director of the Barry University School of Law Extension Program, which provides placement for upper-level students in government, nonprofit, and public sector law offices. Prior to joining Barry, Professor Bonner was a civil trial lawyer in private practice for over 40 years. During his career as a trial lawyer, Professor Bonner successfully represented local governments, law enforcement agencies, individual law enforcement officers, and elected officials in many civil matters in both state and federal courts. After 41 years as a trial lawyer, Professor Bonner retired from the practice of law on July 1st, 2022, to accept the position as an assistant professor at Barry University School of Law. Professor Bonner is a frequent lecturer on a variety of legal topics, including civil procedure, evidence, ethics, and federal practice. That's a really impressive bio. So, Professor, thank you so much for being here today. This is a great topic, defending depositions. If a client were to call me today and ask me about a deposition, I would probably cringe and run away if I could. But after today's training, I'm confident that I will be able to help a client out with defending a deposition. With all of that said, Professor, the floor is yours.
Well, if a person was to call me today and ask about a deposition, I'd laugh and tell them I'm not practicing law anymore, and I'd send them on to one of you folks. So we all have our skeletons in our closets, and practicing law is no longer one of mine. So, but I will try to share with you some of the knowledge that I gained when I was practicing law as far as the defense of depositions. One thing that is very important to know is your client is never going to win the case at her deposition. Absolutely never, ever going to win it. However, it is very easy for your client to lose the case at her deposition. If your client lies at the deposition, if your client panics at the deposition, if your client says something stupid at the deposition, if your client is railroaded into saying something she doesn't want at the deposition, you can easily lose the case. You don't want that to happen. You don't want a bad deposition by your client to lose the case. So how are we going to stop that? How can we stop your client from torpedoing his own case at deposition? And the answer to that question is by preparing your client. Preparing your client to deal with what for your client is the unexpected. preparing your client to deal with a lawyer on the other side who is not her friend, preparing your client to deal with questions that can be confusing. You've got to be able to prepare your client in order to reduce the odds that your client will be her own worst enemy and lose the case at deposition. How do you do that? How do you effectively prepare your client for her deposition? Proper preparation begins long before the deposition starts. You can't just walk into the deposition and expect it to go well. That is never going to happen. You have to use critical thinking. You have to understand what the issues are in the case. You have to understand what the universe of facts is in the case. Thorough preparation is the only way to prevent a disaster from taking place at the deposition. And sometimes you may not even realize the disaster has taken place until long after the deposition. The first thing you want to understand is, why does opposing counsel want to take your client's deposition? Now, for some people, it's a knee-jerk reaction. Oh, yes, we have to depose the opposing party. But there are 4 basic reasons that people take depositions. The first one is to obtain information regarding your client and the lawsuit. That is the number one basic reason for taking a deposition. It is to gather information. I refer to this as an informational deposition. Lawyers who take depositions only at the informational level are merely operating at an entry level. This is a basic level of deposition. But lawyers gather information because they want to know the unknown. They want to know what your client knows. They want to know what your client doesn't know. They want to know the sources of your client's knowledge. The second reason to take your client's deposition is to pin your client down, to make it so your client has nowhere to move when the case goes to trial. By pinning your client down, this will keep your client from changing stories at trial. Or if your client does change stories at trial, it's going to make your client look like a liar. This is a slightly more sophisticated level of taking deposition. The third reason opposing counsel wants to take your client's deposition is to get key admissions from your client, to get admissions from your client that damage your client's case and strengthen your opponent's case. So what kind of admissions does your opponent want to secure? They want to get the admissions that are fatal to your case and that are helpful to theirs. This is an even higher level of sophistication. Lawyers who take this level of deposition have been around for a while. They know what they're doing. And if you're in a deposition and you hear a line of questions where each one starts with, "Would you agree?" that's the type of deposition that's being taken. They're getting one where they're getting admissions from your client. And those are very dangerous questions. The fourth reason people take your client's deposition is to evaluate your client as a witness. They want to know, they want to be able to report to their client what type of witness your client is. Is your client sincere? Is your client straightforward? Or is your client evasive? Does your client try to weasel out of questions by pivoting away when answering? Is your client likable? Likability is very important, especially if it's a case that's going to be tried in front of a jury. And at the end of the day, is your client believable? These are all factors that your opponent needs to consider in moving forward with the case. So how do we deal with this? How do we deal? Preparation is the key to defending depositions. And by preparation, I'm not talking 5 minutes, 10 minutes, 15 minutes before the deposition. I'm talking an ongoing process with multiple meetings with your client to prepare. The first thing you need to understand is there is no such thing as over preparation. No such thing whatsoever. You need to do your homework. You need to do your homework. Where does that homework start? Well, step one of your homework involves reading the notice of taking deposition. And this may sound basic and it may sound simple, but there are a number of lawyers who don't bother to do this. They let their support staff deal with the notice when it comes in, and they're happy if it just gets put on the calendar. That is not good. That is a recipe for disaster. You need to look at the contents of the notice. You need to look at it in its entirety. The name of the witness / deponent. Have they properly identified your client? What is the location of the deposition? Sounds basic, but you need to know this. What is the time of the deposition? Will communication technology be used? In 2020, when COVID hit, one of the positive things that came out of it was the legal community pivoting to communication technology. And one of the first areas where that was embraced was in taking depositions. The Florida Bar has amended the rules to specifically allow for communication technology to be used in taking depositions. So you want to look at the notice and see if communication technology is being used or if it's going to be an in-person deposition. What type of communication technology is going to be used? That has to be indicated in the notice if it is a remote deposition by communication technology. Are there instructions in the notice for accessing the communication technology? Is there a link? Is there some sort of information that the court reporter will provide the link at a later time? You need to know this because your client needs to know how to access the remote deposition if it's being taken by communication technology. Another thing you need to know from looking at the notice is whether your client has been requested to bring documents or items to the deposition. This is a deposition ducis tecum. If it is a deposition ducis tecum, there has to be a list and description of the items requested. How much advance notice is needed for the deposition? You need to look at the deposition and see how much notice is required, how much notice has been given. In federal court, there is a minimum of 10 days required, 2 business weeks. 1.310 in state court just requires a reasonable notice of taking depositions, but does not specify what constitutes reasonable notice. For some reason, the folks at the Florida Supreme Court and the Rules Committee thought that lawyers would work out what is reasonable. And as anyone who has practiced law for more than 30 seconds knows, that is virtually impossible for lawyers to be reasonable when we're talking about discovery issues. Reasonableness of the notice is a factor for subjective determination by the court. Obviously, if the notice is mailed the day before the deposition, that's not reasonable. That's not. Here in Central Florida, we are in the 9th Judicial Circuit. We have uniform guidelines in this circuit requiring at least 10 working days notice to be given in the absence of any agreement among counsel to the contrary. What is the location of the deposition? This is important for a variety of factors. If you are representing the plaintiff, absent a showing of good cause, your client is going to be required to attend the deposition in the forum in which the case is pending. So if your client lives in Miami and has filed suit in Orlando, your client is the plaintiff, your client will likely be required to travel to Orlando for the deposition. On the other hand, if you are representing a defendant who is not seeking affirmative relief, that is, there is no counterclaim involved, your client will not be required to travel to be deposed by the plaintiff. So let's flip it a little bit. your client is the defendant. The lawsuit is pending in Orlando. The plaintiff is in Orlando. Your client will not be required to travel to Orlando for the deposition. Let's say you represent an entity, a corporation, an LLC, a partnership. If you represent an entity that is not seeking affirmative relief, the deposition has to be taken in the county where the entity has the principal place of business. So let's talk a little bit about production of documents at deposition. Depositions duces tecum. That is governed by two separate rules of civil procedure that act together. The first one is Rule 1.310, which talks about depositions on oral examination. But the second one is 1.350. In 1.350 talks about depositions duces tecum, where it says the notice to a party deponent can be accompanied by a request made in compliance with Rule 1.350 for production of documents and things at the taking of the deposition. Because these rules act together, if it is a deposition duces tecum, there has to be 30 days advance notice for the deposition, because you've got to have 30 days to gather up all the documents to bring to the deposition. A lot of lawyers don't understand this. A lot of lawyers don't comply with this. It is not unusual to receive a notice of taking deposition duces tecum that may give you 10 days, 2 weeks before the deposition. That is wrong. That's not consistent with the rules. If somebody just wants to get records from a non-party, they can use 1.351. But if they're taking the deposition of a party under 1.310 duces tecum, there has to be 30 days advance notice for a deposition duces tecum. Again, that is consistent with 1.350. Let's talk about communication technology. As I said, when COVID hit, everybody started doing their depositions by Zoom, by Microsoft Teams, by other forms of remote technology. And the rules have been amended to allow for that. If the deposition is going to be taken by communication technology, the rule says what you have to do. You have to state in the notice that communication technology will be used. It has to state notice of taking deposition using communication technology or Zoom or whatever. The notice has to specify the specific form of communication technology that will be used. The rule allows this to take place by agreement of the parties, by motion, or by order of the court. 999,999 times out of a million, it is done by agreement of the parties. Now, once you have read the notice, if you've seen any problems with the notice, the first thing you should do is reach out to opposing counsel and try to have a civilized conversation about the problems with the notice. So many lawyers resort to emails first. Believe it or not, the good old-fashioned technology of your telephone is often the best way to discuss these things with opposing counsel to try to resolve it. Hey, I've got your notice of taking deposition. You've got the wrong location because my client can only be deposed where she resides. You've got the time frame wrong for a duces tecum deposition, things of that nature. You try to work this out in advance and hopefully they will reschedule. But if opposing counsel is going to be a pain in the backside, document that and then file a motion for protective order and try to get it scheduled for hearing before the scheduled deposition. Make an effort to get it resolved before the scheduled deposition. That is often impossible to do because, as you well know, judges are backed up from here until Christmas almost with all kinds of matters. Your average circuit civil judge in Orange County has over 3,000 cases, and trying to get a hearing on a motion like this is difficult. But try to get it heard before the deposition. If necessary, let the JA know that it is an emergency to get it advanced on the calendar. So, what do you need to do next? Once you've read the notice, it's my firm belief that knowledge is power. You need to know everything that is humanly possible to know. You need to know the case. What is this case about where you were going to be defending the deposition? Review the complaint. Review the complaint that has been filed. What are the allegations of the complaint? What has been alleged by the party seeking relief? What are the elements of the claims that have been alleged? You need to know this. What facts will be needed to prove those elements? Review the answer. That's the complaint. You've got the answer. What are the allegations of the answer and affirmative defenses? What facts are going to be needed to prove those affirmative defenses? You need to know all of the facts of the case before meeting with your client for deposition preparation. What else do you want to do in terms of gathering knowledge? Well, you want to identify, you want to obtain, you want to review all necessary documents. Find out how these documents fit into the allegations of the complaint. Find out how these documents fit into the allegations of the answer and the affirmative defenses. So what is the next step after you've read all the paperwork, or hopefully electrons in your possession? Well, your next step is going to be meetings with your client. And I make that plural for a good reason, because one meeting is not enough. 2 meetings are not enough. Sometimes even 3 meetings are not enough. But at the bare minimum, effective deposition preparation generally requires 3 meetings with your client. 3 meetings at a minimum. First one you might want to call reconnaissance. Learning what your client knows about the background of the case. The second meeting, preparation, indoctrination. And your third meeting is going to be a mock examination of the client to let your client know what to expect at the deposition when the bullets start flying, and to let you know how your client is going to react when the bullets start flying at the deposition. Let's talk about the first meeting, the reconnaissance meeting. You do not need to do this meeting in person. You can do this meeting over the phone. You can do it by Zoom. You can do it by Microsoft Teams, any type of remote technology. But what are you going to do during that first meeting? You want to give your client a general description of what to expect at the deposition. What does a deposition involve? Well, it involves your client, you, opposing counsel, perhaps the opposing party, and a court reporter getting together in a conference room or by technology, and your client being asked questions under oath, sworn to tell the truth. Let your client know that the oath has consequences. Let your client understand that the deposition has consequences. Take this reconnaissance meeting to find out everything your client knows about the case, everything your client knows about the other parties in the case, everything your client knows about any documents, and any thoughts or feelings your client has about the lawsuit. Lawsuits, for lawyers, they're just part of daily life. For our clients, they're not. Lawsuits are a major life-changing event. They are an inconvenience. They are unexpected. Most of our clients are not career litigants. This is a one-time experience for most of our clients. So they're obviously going to have strong thoughts, strong feelings about the lawsuit, about opposing parties, and opposing counsel. Give your client the opportunity to vent, to use you as a sounding board. Take thorough notes during this reconnaissance meeting. In fact, you might want to treat this reconnaissance meeting as if you were taking a entry-level informational deposition of your client. Learning the basics, learning the facts, learning what your client knows about the case. Use this opportunity to determine the identity, the description, and location of all relevant documents. Use this opportunity, this reconnaissance meeting, to make arrangements for your client to obtain full, complete, and legible copies of all relevant documents, and most particularly of any and all documents that have been requested if it is a ducis tecum deposition. Above all, be curious. Be curious about your client. Be curious about the case. Be curious about everything there is to know. Curiosity is important. You need to use this opportunity to learn everything your client knows about the case. What does your client know about the allegations of the complaint? The answer. If your client is the plaintiff, your client is going to be asked about the allegations of the complaint. Know everything there is to know that what your client knows about those allegations. Where did those allegations come from? What is the genesis of those allegations? What does your client know about the facts of the case? Be curious, learn this information. What are your client's sources of that information? Does your client have firsthand knowledge? Is your client relying on something that she read? Is your client relying on something that somebody else told her? Who are your client's potential witnesses? Are there people who can back up your client's story? Find out about this. You need to know this information, because I can guarantee you opposing counsel is going to be asking these questions as well. Again, what are the sources of your client's information? During this initial reconnaissance meeting, you need to find out what information is damaging to your client's case, what information is helpful to your client's case. The reason you need to know this is because you need to be working on a theme or a theory of your case. And if you want to have a winning theme or theory, you have to have one that incorporates the good facts and the bad facts. A theory that encompasses all of the facts together, but still allows your client to prevail. Use this informational reconnaissance session to try to figure out what type of witness your client will make at the deposition. Is your client argumentative? Is your client submissive? Is your client likely to go along and agree to everything that is said? What type of person, what type of witness, what type of personality does your client show? Now, during this initial reconnaissance meeting, let your client know that you're going to have at least 2 additional meetings in person before the actual deposition. And during this initial reconnaissance meeting, the final thing you need to do is schedule meeting number 2 for preparation and indoctrination. Let your client know you need to do this. Let your client know you need to meet in person, and let your client know that this is going to take several hours to meet for the preparation and indoctrination. Preferably, your number 2 meeting, preparation, indoctrination, should be not less than 2 weeks before the deposition, because you're going to need time after that meeting to reevaluate things and to plan the final session, which is the mock examination. But again, no less than 2 weeks before the deposition. Let's talk a little bit about meeting number 2, preparation and indoctrination. What is the preparation aspect of that? Well, number 1, you want to review all documents in detail with your client. Go through every stinking document that you have gathered, every stinking document that the opposing counsel has requested, even documents that your opponent has not requested, and go through them with your client. You do not want to have your client bushwhacked with a document that you have not reviewed with them at the deposition. Go through every document. Make sure there's no gotchas in there. If there is a gotcha in there, work with your client to try to find some spin to put on it so it can help your case. Again, review each and every document in detail with your client. This includes the complaint. It could include the answer. It includes your client's own answers to interrogatories. I've been in way too many depositions where clients are shown their answers to interrogatories and they act like it's the first time they've seen them, even though your client answered them in rough form. Your office typed up their answers, and then your office took them to the client to sign in front of a notary, and your client acts in the deposition like they've never seen it before. That is not a good thing. Go through the interrogatory answers, the complaint, the answer, the affirmative defenses. Preview the deposition setting with your client again. Is it going to be in person? Is it going to be at a court reporter's office? Is it going to be at a lawyer's office? Is it going to be by Zoom? Let your client understand again where it will be, who will be there, what will be taking place. Preview who will be attending. Opposing counsel, possibly opposing party, court reporter, yourself, placed under oath. Preview what happens at the deposition. You're going to be sworn under oath to tell the truth. Preview every topic that you expect to be addressed at the deposition. And again, this does not mean you go through a mock examination. That is going to be the third meeting that you have with the client. But preview all the different topics you expect to be addressed. And preview the types of questions that your client will be asked. One of the things I found is very important is to tell your client where to look when she answers questions. This is important. At an in-person deposition, I would always tell my clients to look opposing counsel in the eye. Come across as sincere, look them in the eye. Do not, under any circumstances, look to me before you answer the question. I can't answer them for you. Listen to the question, look opposing counsel in the eye. If it is an in-person video recorded deposition, I tell my client to look directly at the video camera when answering the questions. Look at opposing counsel when he is asking. Look at the video camera directly when you are answering. It is important to do. Why? Because chances are that's going to be replayed at trial at some time, and you want to have the people on the jury, when it is replayed, see your client looking directly at the camera. If it is a Zoom deposition, a communication technology deposition, I would tell my client to look directly at the camera on the computer. Again, because that way it looks like you're looking directly at the people who are taking the deposition. All important things for your client to know before the deposition. What else do you want to tell your client during the preparation part? You want to tell your client to listen to the question, to pause and think before answering, to tell the truth. I can't emphasize this enough. Tell the truth, tell the truth, tell the truth. I can spin the truth even if it's harmful. I cannot spin a lie. If my client lies in a deposition, it's going to be a disaster for the case. No matter what, always tell the truth. Do not answer a question you do not understand. If you do not understand the question, ask that it be rephrased. Answer audibly. Do not mumble. Do not be soft-spoken. Do not shake your head, nod your head. They can't hear those rocks rattling around in your head when you nod and shake your head. Answer out loud. Be polite. Be polite. Don't be a jerk. Let the other side be a jerk. Do not be a jerk. Be nice. Be polite. Do not argue with opposing counsel. Do not lose your temper. Do not be sarcastic. Do not joke. Do not kid around. Opposing counsel is not your friend. Opposing counsel may come in and be the nicest person in the history of nice persons at the deposition. Opposing counsel is not doing that because she wants to be your friend. Opposing counsel is doing that so you will let down your guard and say something that is harmful to the case. If you need to take a break, let everyone know. It is not the Boston Marathon. You can take breaks, not a problem. If you do not know the answer to something, let us know that you don't know. If you don't remember, say so, but don't use "I don't recall" as a crutch. Because if you're asked a bunch of really easy questions and we've got 200 "I don't recalls," you're going to look like an idiot at trial. Tell the truth, but tell it as simply and directly as possible. Don't take the bait if there is a long period of silence by opposing counsel. Some lawyers use that because people simply can't stand having a period of silence and they're going to start volunteering information. Do not volunteer information. Don't exaggerate. Don't think out loud. Don't do anything stupid. So, indoctrination. Explain what opposing counsel is trying to accomplish. Again, explain that opposing counsel is not your client's friend. Explain that opposing counsel is there to get admissions helpful to the opponent's case and harmful to your client's case. Review opposing counsel's perceived case themes. Think about what case themes would be appropriate for opposing counsel and explore those and review those with your client. Review your own case themes with your client. And when you do this, consider all documents and lines of questioning that opposing counsel could pursue. Review the basic rules for answering questions, which I just went over several of them. Number one, pay attention. Number two, answer only the question that has been asked. One of the examples I would give for that would be, if I ask you, do you know what time it is? The answer is not 12:30 p.m. The answer is yes or no. Pay attention to the question. Answer only the question that has been asked. Answer that question as briefly as possible. And again, I repeat for the bazillionth time, tell the truth. Got to get your client to anchor every one of her answers in the truth. There is no harm in the truth. We've got to anchor the case in the truth. I will develop a theme. You will develop a theme that includes the truth, all of the facts. You need to let your client know not to be afraid of the truth, because lies are going to kill the case. Lies are more damaging than the truth. So many cases have been lost by stupid lies because once the jury identifies your client as a liar, you've got nothing left. So, the second session is a teaching exercise. What you're trying to do is to teach your client how to be a witness. And hopefully your client is learning how to be a witness. You might want to consider using a whiteboard or a flip chart or something to write out the main facts, the theories, and the themes during this meeting as if you're trying to teach. And at the conclusion of the meeting, you might want to give your client a binder and send your client home with a binder of all the documents, and give your client an assignment, just like you would if you were teaching. Give your client an assignment to study and know these materials, to study and know the facts, study the complaint, study the answer and affirmative defenses, study the answers to interrogatories, study every relevant document in the case so you know them backwards and forwards when you come to the deposition. Give your client this homework so your client will be prepared. And then you want to schedule the third meeting. Schedule the third meeting, which is the mock examination. Mock examination, you want to meet with your client in person to take a mock deposition. And it may not be you, it may be somebody else from your office to come into play the opposing counsel. There would be times when I was practicing where I would be brought in to come beat up on our client in a mock deposition. One of the other lawyers say, hey, my client's got the deposition coming up. I need you to come in and be bad Bob, be mean Bob, and to grill the client as if we expect it to be a difficult deposition. So you need to meet with your client in person to do this mock deposition. And you or your colleague in the office has to prepare for that mock deposition as if you were the adverse party taking the deposition of your client. You want to frame every question the way your opponent would frame it. You want to ask every conceivable question that your opponent would ask. And you want to make sure that you ask those questions in the same manner that you expect opposing counsel to ask them. Is opposing counsel someone who's smooth? Is opposing counsel someone who is in your face? Is opposing counsel someone who's a little tricky? Try to ask the questions the same way you expect opposing counsel to ask them. This helps your client prepare. But it also helps you identify questions, identify techniques, identify answers and responses where there's problems. You can't take it easy on your client during this mock deposition. Can't do that, because if you take it easy on your client and your client thinks this is going to be a breeze and then goes in and gets her head kicked in the deposition, you haven't done your client any favors whatsoever. One thing you might want to consider doing is videoing the mock examination to review with your client, because let's face it, not all of our clients are the best and the brightest. And some of our clients are arrogant. Some of our clients have a higher opinion of themselves than is justified. So you might want to consider videoing it so your client can see exactly how he messed up in the mock deposition and areas that need improvement. Use this as an opportunity to critique not just the substance of the answers, but your client's manner of answering the questions. Your client snarky? Was your client sarcastic? Was your client rude? Was your client just not a nice person when answering? You need to be prepared for this. There are some special precautions you need to understand if the deposition of your client has been noticed as a video deposition. First thing is, why would opposing counsel want to take a video deposition of your client? I can tell you one very good reason. Because opposing counsel wants to make your client look bad and show it to the jury. Your opponent is hoping that your client will come in and be a jerk. Opponent is hoping your client will come in and be unprepared. Your opponent is hoping that your client is going to come in and be a train wreck. And because your client's a party, they can use that deposition as substantive evidence at trial. And if your client is a mess in the video deposition, I will guarantee you will be played for the jury. So you want to make sure your client is aware of this. You want to make sure your client is going to be dressed appropriately for the video deposition. You want to make sure your client knows where to look at the video camera, to be polite, to be kind, to be a gracious person during the deposition. Again, video the depo prep, particularly if it is going to be a video deposition by your opponent. And by videoing it, you can have your client practice looking at the camera during the answers. You can review the video with your client. How do you get a good deposition by your client? You practice, you practice, you practice. And when you're done practicing, you practice some more. Championship football teams, championship basketball teams just don't roll out the ball on game day and compete and win championships. They put in practice, and that's the only way you're going to get a winning performance by your client at the deposition. Let's talk about the next step, the actual deposition, the deposition itself. You are going to be defending the deposition. And when you are defending the deposition, you may from time to time make objections. This is an area where many lawyers fall woefully short because they do not understand or don't care how to make objections in a deposition. The very first deposition I went to as a young lawyer, eons and centuries ago, there was another lawyer who was taking the deposition who was one of my contemporaries. I think we'd both been admitted for about a month. I was representing a co-defendant. My contemporary was taking the deposition of the defendant's representative. The counsel representing that defendant did everything inappropriate that could be done in that deposition to throw the young lawyer off. And I felt embarrassed for the lawyer making the objections. I felt embarrassed for the lawyer taking the deposition. It was horrible. First thing you need to know is that any objections during a deposition have to be stated concisely in a non-argumentative and non-suggestive manner. 1.310C says in part, any objection during a deposition must be stated concisely in a non-argumentative and non-suggestive manner. So what is the proper form of an objection during a deposition? Proper form is to simply say, object to the form. You may go a little step further, object to the form leading, object to the form compound, object to the form argumentative. Technically, you don't need to do that. All you really need to do is say the magic words, object to the form. 4 little words, and that's enough. Unless your opponent says what's wrong with the form, then you identify what's wrong with the form. Leading, compound, argumentative, things of that nature. But again, proper objection concisely states the basis. If you read the cases that have discussed this, if you look at the discovery handbook for the Middle District of Florida, they all say that all you need to do is say object to the form. That's it. Do not suggest the answer. Do not be rude. Do not be one of those lawyers we're going to be reading about in the disciplinary actions. You just have to concisely state the basis. Object to the form. 4 words. allows for the objection to be stated in a non-argumentative, non-suggestive form, gives the lawyer who's asking the question the opportunity to correct the defect. Speaking objections, not permitted. Speaking objections, not permitted. When I was a young lawyer and had to index depositions that other lawyers took as they were getting ready for trial, I would sometimes read transcripts where there were pages and pages of speaking objections for each line of question and answer. It was enough to give you a headache. Coaching the witness, suggesting the answers through objections is improper. Objection. There's no way he could have seen that. You may answer, no, there's no way I could have seen that. Do not suggest the answer through your objections. We'll be reading about you in a disciplinary proceeding. Instructions not to answer. This is something where a lot of lawyers fall short. When is it proper to instruct the witness not to answer? You can instruct a witness not to answer only when necessary to preserve a privilege, to enforce a limitation on evidence directed by the court, or to present a motion under subdivision D. Subdivision D is a motion to terminate the deposition. So, privileges: attorney-client privilege, work product privilege, spousal privilege, psychotherapist patient privilege. Those are privileges. Limitations on evidence directed by the court. You've already been to court. You've had a motion for protective order. The court says you can't inquire into these areas. And yet, despite the fact that there is a court order saying you can't inquire, the lawyer wants to go into that area. You can then instruct the witness not to answer. You can also instruct the witness not to answer if it is becoming burdensome, oppressive, harassing, turning into a street fight at the deposition, and you're going to move to terminate under subdivision D. Let's talk about a special area of privilege. Fifth Amendment privilege in civil cases. Can your client assert the Fifth Amendment during a civil deposition? The answer to that question is a resounding yes. Are there consequences to doing this? Absolutely, there are consequences. I once had a case where there were probably 9 or 10 plaintiffs involved. The plaintiffs were being prosecuted, and they decided the best defense was a good offense. So they sued the prosecuting attorney, they sued the law enforcement agencies, and they were claiming that it was wrongful prosecution. Meanwhile, they're being prosecuted for all kinds of drug offenses. And when we went to the depositions of those parties, as soon as they got done saying their name and their address, for the rest of the deposition, they would go on, upon advice of counsel, I'm asserting my Fifth Amendment privilege to refuse to answer that question on the grounds that it might incriminate myself. They had index cards in front of them that had those words on it. I just would go there and I would keep tally on the amount of Fifth Amendment assertions. 1, 2, 3, 4, zoom 5. And usually there would be several hundred during the deposition. There are consequences to that. You have the right, your client has the right to assert the Fifth Amendment privilege against self-incrimination with respect to specific questions, but it has to be done on a question-by-question basis. You cannot just go in at the beginning of the deposition and say, I am going to assert the Fifth as to every stinking question after my name and address. Can't do that. If your client is going to assert the Fifth Amendment, it has to be done on a question-by-question basis. One question at a time. Makes for a lot of long and boring and, for the lawyer keeping the Fifth Amendment tally, amusing depositions. Your client cannot use the Fifth Amendment as a sword and a shield. So what does that mean? It means if you are a plaintiff trying to assert the Fifth Amendment, you've got a problem. Definitely got a problem as a plaintiff. A plaintiff who is seeking affirmative relief in a civil case cannot invoke the Fifth and refuse to comply with the defendant's discovery requests. Can't do that. If you do that, what is going to happen? Well, court may compel your client to take the stand and assert the privilege in court, and the judge may, in fact, strike your case if it goes to the heart of the case. You can't hide behind the Fifth while seeking affirmative relief on the same core area of facts that your case turns. Can't do that. A little bit different if you are a defendant. If you are a defendant, the court can compel your client to take the stand and assert the privilege in response to questions. And the court can instruct the jury to adverse inferences if your client asserts the privilege. And the court has the right to strike pleadings to the extent that the assertion goes to the heart of the relief sought. If you represent the plaintiff, more often than not, the court will dismiss your client's action or strike the pleadings. And the most recent case I could find on that was Perez v. Gallego, third DCA case from 2023. Now, if you are representing the defendant, you might, under the appropriate circumstances, and once again, spell check was the bane of my existence, should be a party who is a defendant. You may be able to get a stay where your client is a defendant in both a civil and a criminal case, and being forced to choose between waiving the Fifth Amendment and losing the case on summary judgment. But that is only in very rare, limited, special circumstances. I would not want to hang my hat on that one, but it's worth trying. Okay. Let's talk about improper behavior by opposing counsel. If you have done this long enough, you are going to go to depositions where opposing counsel behaves badly. Depositions provide great opportunities for unprofessional behavior. In the past 2 years, a lawyer was recently suspended for a total of 91 days during a Zoom deposition for texting his client answers during the deposition. Not the way you want to see your name mentioned in the Florida Bar News, getting a 91-day suspension for telling your client how to answer questions by text message during a Zoom deposition. Other lawyers have been disbarred because of unprofessional conduct over multiple cases and multiple depositions. Any of you from Central Florida, if you want to get on to Westlaw and Google Beavis and Butthead, it's not just a cartoon that used to be on MTV. There was a case involving bad deposition discovery behavior by plaintiff and defense lawyer in a civil deposition where the Fifth District Court of Appeal said that their behavior was more akin to Beavis and Butthead than to professionals engaged in the practice of law. The lawyer who is taking the deposition has a professional responsibility to treat you as opposing counsel and the witness or the party being examined with dignity, with respect, and with courtesy. Unfortunately, it doesn't always happen that way. There are lawyers who like to get into scream fests at depositions. They like to be hostile. They like to be aggressive. They like to harass and intimidate people. They like to jump up and scream and point the fingers at the witness. Don't do that. There are lawyers who like to intentionally mislead witnesses or parties. You cannot do that. Intentionally misleading a witness or a party is unprofessional and not permitted. One example of that would be purporting to read from a document that does not exist and misrepresenting what a document that does exist actually contains. Misleading witnesses not permitted. So what should you, as the lawyer who is defending a deposition, do if this type of unprofessional behavior occurs? The proper response in my book, based on my experience and what I teach my students, is the following. If opposing counsel exhibits improper or unprofessional behavior, the first step, number one step, is to object and concisely describe the improper conduct. Objection, counsel has jumped up, is shouting at the witness, is leaning across the table, and is jabbing his finger in the face of the witness. If the deposition is not being video recorded, you need to consider yourself as the play-by-play announcer at a sports event when you object and describe what is going on. Objection, counsel has raised his voice and is shouting at the witness and is screaming obscenities at the witness. Again, play-by-play announcer describing what's going on. One of the great things that we have these days is we have technology at our disposal. And when I was still practicing, I would take the opportunity to be the next Steven Spielberg by getting out my phone and videoing bad behavior by opposing counsel. I was once at a deposition where opposing counsel started chasing one of the other lawyers around the conference room table where the deposition was taking place, and got out my phone, put on the video camera, and I started describing the race that was going on around the conference table by this. So you describe it, you document it in some way, shape, or fashion. Remember, there is a court reporter present. Do not ever let anything go off the record at a deposition. If it turns into a scream fest, if it turns into somebody chasing somebody around the table, you want the court reporter taking everything down that is said. Now, if the bad behavior continues, you should move to terminate the deposition or adjourn the deposition. Don't say, okay, I'm through with the deposition, because it might be misconstrued as you saying you don't have any questions or anything like that. There might have been some areas you wanted to clean up, but make it clear that because of the improper conduct of your opponent, you are adjourning the deposition, and you'll be filing a motion to seek relief from the court. Now, before you pull the pin on this grenade, you should exhaust all efforts possible to resolve the dispute that threatens the ability to proceed forward with the deposition. You should give a couple of strikes, and if the lawyer continues, you've got it documented. You've got a pattern of behavior here that is on the record to take to the judge. 1.310D, motion to terminate. At any time during the taking of the deposition, or on motion of a party or of the deponent, fancy word for witness, and on a showing that the examination is being conducted in bad faith or in such a manner as unreasonably to annoy, embarrass, or oppress the deponent or party, or that objection and instruction not to answer are being made in violation of 1.310C, the court in which the action is pending or the circuit court where the deposition is being taken may order the officer conducting the examination to cease immediately from taking the deposition or limit the scope and manner under 1.280C. I tell you right now, 99% of the time, you will never get the judge who is presiding over your case to take your call in the middle of a deposition that's gone off the rails. And if the deposition is taking place in a circuit other than the one where the case is pending, there is not a single judge in that circuit who wants to get involved in that mess. So what you're going to need to do is you're going to make a verbal motion, an ora tennis motion to terminate, to adjourn the deposition, and then file a written motion as soon as possible and get a copy of the transcript and attach it to it. Upon demand of any party or the deponent, taking of the deposition must be suspended for the time necessary to make a motion or for an order. That's what you do. You move to suspend the deposition, to adjourn it, so you can file a written motion with the judge to get your idiot opposing counsel to back down and not be like a mad dog foaming at the mouth. Now, the good news for you, 1.380A applies, which means you are going to get an order awarding you attorney's fees and costs if in fact your opponent was being an idiot. A party or witness who believes the deposition is being conducted in bad faith can move to terminate or limit the deposition and move for a protective order. You need to do this. You describe the bad behavior on the record. You give them 1 strike, 2 strike, maybe 3 strikes. And if that doesn't work, you make your ora tennis motion to terminate or adjourn. You leave, you go file your written motion. You contact your good friend, the court reporter. You get a copy of the transcript and attach that as an exhibit to your motion. And if there is a video, attach the video file, which will show and document even better the bad behavior of your opponent. You don't want to have to deal with somebody getting in your client's face. So what are the consequences? Well, disciplinary action in addition to getting a do-over on the deposition. Disciplinary action, even though I'm retired from the practice of law, every month at the end of the month, I like to go to the daily news summary of the Florida Bar to read the monthly disciplinary actions because I'm easily amused. And stupid things that lawyers do, I generally tend to share with my civil procedure students with the hopes that they won't end up there someday. But despite the facts that there are clear rules about what you can and can't do in a deposition, you know, some people just don't get it. You never want to be the subject of Florida Bar disciplinary action. And you certainly don't want to be the subject of disciplinary action so many times you've got Roman numerals after your name. So the case of Mr. Ratner, who is now a former member of the Florida Bar, who will never be coming back even in the reruns, he was publicly reprimanded by Supreme Court of Florida, suspended for 60 days, and put on probation for 2 years for deposition misconduct. And here is a brief description of what he did. He forcefully leaned over the deposition table, lambasted, I guess that's a polite way of saying shouted, at opposing counsel in a tirade, tore up an evidence sticker, wadded it up, and flicked it or tossed it in the direction of opposing counsel. So he got a 60-day suspension. 5 years later, deja vu all over again. Ratner 2, suspended with conditions for bad behavior, being a jerk during discovery. Then suspended with conditions. Got to give you one more chance here, Mr. Ratner. And then 3 years later, we've got Ratner 3, disbarred. Not coming back from that one, folks. Y'all put a lot of time, money, and effort to become a lawyer. Law school is expensive. It's not as cheap as it was when I went to law school 45 years ago. You spent money on bar prep courses. You have invested a great deal of time, money, effort to become a member. Do not throw it away by being a jerk during your depositions. Let's talk a little bit about federal court. Probably during the second half of my career, the lion's share of my practice was federal court civil rights litigation. I loved federal court. Some of you may litigate in federal court, and if you do, God bless you. I find it a lot more civilized area in which to practice. Why? Because the judges have zero tolerance for nonsense. Zero tolerance. In state court, there is no time limit on depositions. I've had depositions in state court cases when I was practicing that lasted 5 days, 6 days, 7 days. They could go on and on and on, depending on the stamina of the lawyers and the imagination as far as asking questions. Federal court requires you to be focused. There is a 7-hour time limit on depositions in federal court. But my favorite part of federal court dealing with depositions is the ability to get the magistrate judge to deal with unprofessional conduct during depositions. When I practiced, I had the chambers number for every magistrate judge in the Northern District, Middle District, and Southern District in my contacts. And many times in depositions, if things went off the rail, I would make a motion to adjourn the deposition to get the magistrate on the horn. And you want to make sure, if you are litigating in federal court, to have that magistrate's telephone number on speed dial so you can call the magistrate and get them on the horn to resolve issues that come up during your depositions. I never once had a magistrate fail to take my call when I reached out during depositions where somebody was engaging in bad behavior. And that is something that is such a benefit to have. You're allowed to do this. You should do this by reaching out to the magistrate. And by doing this, you can nip it in the bud and get the deposition to get kickstarted back in the right direction with the blessing of the magistrate. So that is my sales pitch for the wonders and the joys of federal court. Questions?
All right, so I don't see any questions on the Q&A section. Somebody did send me a question related to the materials. I dropped the information on the chat that we will be sharing the PowerPoint slides. I've gotten some great feedback. I know we went a little bit over time. I'm gonna drop the CLE information here again, and I'm about to read the CLE code out loud if anybody wants to write it down. The CLE code is 2407367N. So I'm getting great feedback. This was an excellent presentation. A lot of thanks to Professor Bonner. I don't see any other questions at this point. This was a great presentation, a lot of helpful materials. As a legal aid advocate myself, I feel way better prepared now to handle deposition defense. Some great examples. I want to look more into that Ratner trilogy. It seems like there was like a sequence of events. I'm really hopeful that we never have to worry about Roman numerals right next to our name in the Florida bar. But great presentation. I still don't see any questions. So any final remarks or comments, anything that you want to add, Professor?
Just the more that you put into getting your client ready for deposition, the less likely it's going to be that your client is going to screw something up. And I see Megan McDonough has a question, it looks like.
Yes, let me see if I can allow her to. I don't know if she wants to go off mute or she wants to drop the question here, but I'm going to try to make her a speaker so she can. All right, so Megan, if you want to go ahead and just ask the question, I just mark you as allowed to speak. So
thank you, Jorge, and good to see you again.
You too.
Professor Bonner, I have depositions coming up in a family law case, and my client is initially from Nigeria, And she has a very thick accent. She's very soft spoken, but the worst thing is that she does not answer what you ask her.
Oof.
And we've gone, it is, I don't know if it's a cultural issue, but she just will not answer something. I mean, you could ask her a direct question, what is the address to your house? You're not getting an answer that's an address. Now, aside from doing a lot of prep, have you ever dealt with this before, or have any suggestions on how to deal with this when you just have a client that is just they're gonna be non-compliant even if you prep them?
Yeah, I represented a lot of governmental clients, and I can tell you generally the worst people in depositions are politicians, elected government officials, because they like to talk, but they don't like to answer questions directly. I know, shocking. Absent, kicking them in the ankle every time they do something wrong, or using a cattle prod, which I would not recommend because the Florida bar would frown on that, as would the local law enforcement. Does your client have a family member that you can work with to help her understand the importance of answering the question that's asked?
She has adult children, but they've not been involved at all in this process. In fact, she didn't even tell them until later in the process that it was happening.
Are they friendly to her position, or are they
they're not taking sides?
Not taking sides.
Yeah.
And would one of them possibly be willing to at least help with you getting her pointed in the right direction? And if not a friend, a neighbor?
No friends or neighbors, but a child may be a good starting point.
If your client is a member of a church, maybe a clergyman.
Okay.
There's got to be somebody there, I would hope, who could get a connection.
Okay. And once we get somebody who has a connection, and they just would need to explain to her that she needs to be direct and just answer what's asked.
Yes. Is English her native language?
I would say probably not, but I've never directly asked her that.
Because maybe that's part of the problem. And if English is not her native language, perhaps getting someone who speaks her native language to work with you to help her to understand the importance of answering the question directly, simply, shortly, and only the question that's asked.
Okay. That's a good idea. Thank you so much.
Hey, you're welcome.
Right. So I don't see any other questions. I do see some
I see
comments.
2 questions regarding Fifth Amendment there.
All right. So I see Hillary said, if it's a cultural issue, you need to understand how her culture deals with answering questions. There might be rules that she can explain to you. And Paul Ferreira asked, I have 2 questions concerning invoking Fifth Amendment rights. Let me see if I can bring Paul off. There you go, Paul. The floor is yours. If you're muted, but you can unmute yourself if you want to go ahead and ask the question.
Can you hear me now?
I can.
Yes.
Okay. So, Professor, my question is, when a witness invokes their Fifth Amendment rights in a civil deposition, assuming that they don't answer any of the questions before trial, can you use that invocation to get a negative inference from the jury, because this is a matter of civil damages, money, and in the civil case, a person's liberty is not at stake? But I've read case law it's evidence question where you can't ask for negative inference.
I think if you read that case that's in the materials, that actually has a pretty up-to-date statement of what the law is. If you are the plaintiff who is seeking money damages, you're in all likelihood going to get your complaint stricken before the case ever gets to a jury.
Okay.
If you are the defendant, then you may end up having your client get called to the stand and have to take the fifth and then get a negative inference.
Mhm.
Or if it goes to the heart of the matter, it could get his defense stricken.
Okay. All right. Thank you.
All right, I dropped the link to the materials right now if people want to go through the slides. I will include those the link to the materials as well in the email that will go out in less than 24 hours. The recording will also be uploaded to YouTube probably within the next few hours. But again, Professor, just wanted to thank you for your time and this amazing presentation. We're definitely in a better position to advocate on behalf of our clients when it comes to defending depositions. So with all that said, have a great Friday. Thank you again, and we'll see you
quite
in the next
welcome.
training.
The one thing I will add is defending depositions is a major pain in the backside.
Well, it's
I
not as
don't-
painful after the training.
Yeah.
Thank you again, Professor. Have a great
Take care.
day, and everybody have a
Bye-bye.
great weekend.